Hi, everyone. If you've been researching anything related to VA special monthly compensation lately, you've probably heard of a recent Federal Circuit case, Berry versus McDonough. Here's Berry in a nutshell and why veterans interested in special monthly compensation should pay attention. In Berry, the U.S. Court of Appeals for the Federal Circuit held that VA regulations clearly allow more than one intermediate rate increase for special monthly compensation, also known as SMC. That may sound technical, but it is a meaningful win for veterans with multiple severe service-connected disabilities. Here's the background in plain terms. Under VA's SMC system, veterans can be paid above the basic SMC levels when their disabilities are especially severe. One way VA increases compensation is through intermediate rates under 38 CFR Section 3.350F. These intermediate rates sit between the lettered SMC levels, such as between SMC-L and SMC-M. Before Berry, VA had been relying on a Court of Appeals for Veterans Claims decision that said a veteran could only receive one intermediate rate increase total, no matter how many qualifying disabilities they had. VA often used that interpretation to cap benefits, but the Federal Circuit rejected that approach. The court held that VA's regulation is unambiguous and does not limit veterans to only one intermediate rate increase. If a veteran separately qualifies for multiple increases under the regulation, VA must consider each one. In short, the Federal Circuit reversed the Veterans Court and clarified that VA was reading its own regulation too narrowly. So, when should a veteran care? You should pay close attention if you already receive SMC at the L level or higher and have multiple separate service-connected disabilities involving loss of use, paralysis, blindness, or the need for aid and attendance, and VA previously told you that you were limited to a single intermediate rate increase. This decision is especially relevant for veterans with complex SMC fact patterns, such as multiple extremity disabilities, combinations of aid and attendance with other qualifying conditions, or staged SMC awards over time. Who does this apply to? So it applies to veterans whose claims are currently pending at VA, the Board of Veterans' Appeals, or any of the courts, or previously denied or underpaid because VA capped intermediate rate increases. In some cases, this decision may support higher ongoing SMC payments or retroactive benefits depending on the procedural posture of the claim. Here's the bottom line. Berry versus McDonough expands how VA must apply intermediate SMC increases, and it reinforces that veterans are entitled to every benefit allowed under VA's own regulations. If you want more breakdowns like this, including examples and visuals, CCK Law's blog and videos go deeper into SMC and recent court decisions. Thanks for listening.